So, Chapter 12, Employment Law. Again, as I said, we'll be looking at a general overview of employment law. And by doing so, we'll first distinguish what employees are from agents and from independent contractors. And then we'll look at some common law obligations of both employers and employees. You also see that employees do have obligations. You may be surprised with some. And then we'll briefly look at some statutes, such as workers' compensation, employment insurance, health and safety. And the last part, labor unions. Actually, you may see my slides, they are dark because we don't touch upon collective agreement. We don't touch upon unionized workplace in this course. Most, if not all, but most of B-Law instructors at BCAT. So I will not be talking about unionized workplace, nor will you have such a topic in your final exam. So your final exam, only the part for employment law. I'm excluding the last part of this chapter. Okay, so remember this. So let's start, and you may want to either use your mic or the chat to help me with minimum wage. What is the current minimum wage here in BC? And by the way, it's a new one, effective last Monday. Do you know how much it is nowadays? Uh, 15, almost 15, not there yet. Any other guesses? 13? No, not that low. It used to be 13.85 until Monday, but then from Monday on, June 1st, 14.60, almost there. You had 14.65, so you had it 5 cents more. So it's currently 14.60, 1460. That's the general minimum wage, because there are some positions in which the minimum wage is different. And the main one for us is liquor servers. Do you know the minimum wage for liquor server? The new one also effective last Monday? Yes, great. On spot. So 13.95 exactly. And for liquor servers, it is it's always been different, a little bit lower, because they usually share the tips. But guess what? The provincial government decided that from next year on, the general minimum wage and the liquor server minimum wage will be the same. So from June 1st, 2021, it is going to be 15.20 to general positions and also to liquor servers. Okay, so they have decided to change this. Great. Hours of work. So what is there a limit for us to work in a day or in a week? What is the maximum amount, if any, amount of hours can we work during a week or during the day? 40 hours a week? What about in a day? Is there any limit for a day? 12 hours? All right, let me tell you this. 8 hours. Okay, let me tell you this. There are no limits. There are no limits, no objective limits. There is a subjective limit. Subjective limit is related to as long as if it is unsafe for an employee to be working that many hours, then the employee has to stop working. But what I'm saying is, theoretically, an employee could be working for 24 hours. There are no limits in a day. The same thing for the week. No limits for the week. What you mentioned, the 8 hours, the 12 hours, the 40 hours. So there are limits in which overtime pay is not applicable. So if you work up to 8 hours a day or 40 hours per week, you are not entitled to overtime. But if you work over 8 hours a day, but fewer than 12 hours a day, you are entitled to 1.5 your hourly wage. And if you work over 12 hours, you are entitled to 2 times your hourly wage. So the limits that we learned, they are related to either normal hourly wage or overtime. Okay? But there are no limits, no specific, no objective limits. What there are, as I said, hours in which you will be entitled to overtime. And again, more than 8 hours. So from 8 to 12, you will be entitled to 1.5. And then from 12 on, you are entitled to 2 times your hourly wage. Okay? And rest periods. So does it count by day or week? It counts. Well, it's gonna count overtime after the week. So if you work, let's say, 10 hours today, but you work 6 hours tomorrow, and then 8 hours the other 3 days, you are not entitled to overtime. So yes, the first calculation is going to be on the week, and then it may be applied on a daily basis after the week. So good question. Is that clear? Yeah, so the rest periods, we are entitled to a rest period. We are entitled to a daily rest period and to a weekly rest period. So daily rest period means from one daily shift to the other, we are entitled to an amount of hours. How many hours do you think we are entitled to on a daily period? Any guesses? 8. Yes, that's 8. So we are entitled to 8 hours from one daily shift to the other. However, if we do not have the daily rest period, it doesn't mean it is illegal. It just means that we have to be paid overtime. Okay? So overtime may count also when our rest period is not complied with. And the rest period for week shift, so from one week shift to the other, is going to be 36 hours. So 36 hours from one week shift to the other. Again, assigning workload in the rest period is not illegal, but overtime has to be paid. Okay? So we discussed overtime. Vacation. There are 2 things about vacation. One is the vacation pay. The other is the vacation entitlement. Sorry, not entitlement, but the time to spend without working. So the vacation pay, everyone is entitled from day one. From day one of your employment, you are entitled to vacation pay. The minimum is 4%. and you may be paid on every pay step, or you may be paid up to 2 weeks before you go on vacation. Who chooses this? Your employer. Your employer has the right to decide if they want to pay you on every pay stub or if they want to pay you before you go on vacation. So you are entitled to vacation pay since day one. And by the way, it is minimum 4%, but there are companies who are offering more, 5, 6%, because they find it difficult to hire people, so they would offer more. But minimum 4%. When are we entitled to go on vacation, to spend our time? Well, we are entitled to go on vacation after 1 year of service. So we need to complete 1 year of service so that we are entitled to go on vacation. And minimum vacation time will be 2 weeks. Minimum 2 weeks. Okay? Again, companies may offer more time, but if they do so, it's going to be a benefit and they have to comply with it. But minimum will be 2 weeks. So there's a question here. Are you entitled to vacation if you are temporary 2 months? Yes, you are entitled to vacation pay, not vacation time. Okay? Vacation pay, yes, you are entitled, whether you are temporary or permanent. You are entitled to, except for salaried workers. Because salaried workers, they go on vacation and they keep on getting their salary. So then they have paid vacation as a benefit already. But if you are an hourly wage employee, then yes, you are entitled to vacation pay, even if you are a temporary work. Okay, and minimum 4%. Holiday. So holiday. Um, how many holidays are there in BC? Do you know that we have provincial holidays and federal holidays? And they differ a little bit, they slightly differ. Well, instead of how many, do you know the two provincial holidays we have in BC that are not federal ones? There are two provincial holidays in BC. Family Day, yes, that's right. One more, not so difficult. Boxing Day, no. What province do we live in? Do we have a day for our province? Yes, BC Day. BC Day is provincial. So Family Day and BC Day, they are only provincial holidays. That's why those days you see employees from post office, banking, transportation, because they are federally regulated employees. They are not on holiday. Okay, Victoria Day, we may confuse a little bit, but Victoria is related to the Queen. So Victoria Day is a national holiday, is a federal holiday. We just get confused because Victoria is our capital, but it is a federal holiday. There's one federal holiday that is not provincial holiday. So in this day, federally regulated employees would be off, but BC employees would be working. And I see this holiday already in the chat. It is Boxing Day. So Boxing Day, the day after Christmas, is a federal holiday only. So only federally regulated employees will have Boxing Day. Okay, I know some companies in BC they have Boxing Day as an optional day to go to work. They usually allow employees not to work, but again, this is a benefit. It's not a holiday, provincial holiday here. Okay, right. All other holidays, they are both federal and provincial. Is sick leave a right? So let's say you're sick. Is this a right? Are we entitled to sick leave? No. The answer is correct. No, we are not entitled to sick leave yet, because the federal government wants to pass legislation for 10 sick leave days in a year. And if the federal government approves, eventually provinces they may pass legislation. But as of now, no, sick leave is not a right. And when I say sick leave is not a right, what I mean is you may call in sick, you don't go to work, but then you don't get paid. I know a company, well, I know IKEA, for example. I know IKEA, they offer to their employees 5 sick days in a year. Well, if they are offering, then they become a benefit and they have to comply with it. But it's not a right. What I'm saying is IKEA offers 5 sick days to their employees as a benefit to them. So in case an employee calls in sick for up to 5 days in a year, they will still be paid their average pay in that day because it is a right. All right, so this is just a warm up. We won't actually be touching upon many of those individual rights in this lecture. It's going to be more of a legal nature, an overall legal nature in terms of employment law. But I usually find it interesting to start with this because either students are curious about some of their rights, or students want to correct some of their misconceptions or confirm what they already know. So that's why I start with this kind of warm up. All right, so let's move on. Let's now see what is employment. Well, employment is actually when one person is doing work for another, or for an institution, or for a corporation, for a company. So it is usually defined in legal matters or in the legal arena to be a master-servant relationship. And why master-servant? Because the master, the employer, is the one giving directions, is the one providing the resources, the tools. So that's why it's a master-servant relationship. Okay, where the master will be giving directions. Because if you are an independent contractor, you are actually providing a service. You are in a service agreement. And being in a service agreement is different from being an employee. Because employee will have obligations, but will also have rights under employment law. So this distinction is very important. And how do courts, how do governmental agencies define whether a relationship is an employment one or an independent contractor one? Because sometimes companies and people, they are involved in fraudulent relationships. Companies, well, first of all, if you work or if you have already worked, you may remember that in your pay stub, there will be deductions for employment insurance, for CPP, Canada Pension Plan. There will be taxes. There will be provincial taxes withheld. There will be federal taxes withheld. And depending on the company, you have to co-participate in the benefits. So they may deduct 50% of your benefits premium. So it means it is cost. Companies spend more money than the salary, than the wage, and the employee gets less because there are those deductions, those discounts. So sometimes people and companies, they come into a fraudulent agreement because even though there's an employment relationship, they agree on an independent contractor legal relationship, which is fraud. So courts, government organizations such as CRA, they don't consider or they don't regard what is written in the paper. They want to apply some tests for the real relationship. And the tests they apply, they are known as the control test and also the organization test, the tools test. So the control test, quite straightforward, because an employer actually controls what an employee does. An employer controls based on directions they give to an employee. So I am an employee of BCAT. So BCAT controls me or tells me that I can only deliver the lectures or courses I was hired to. I have timing to follow. I am instructed on what resources I can use, tools they provide me, etc. So they control me. Whereas if I bring to a lecture a guest lecturer, someone to speak about a specific topic in law, it is clear that BCAT does not control this guest lecturer, because the guest lecturer is just coming on an irregular basis just to speak about a specific topic, was invited. So this guest lecturer would be just an invite or could be someone hired just for one lecture as an independent contractor. Okay. Other examples of independent contractors. Well, if you live in a house and you have a garden, you don't need to hire an employee to be your gardener. You will hire either a company or a person as an independent contractor to come and do the garden for you. And the gardener will bear the risks of their activities. They will use their own tools, resources. They may decide to hire hourly employees to help them out or not. So it is clear that in an independent contractor relationship, what is agreed upon will be the major terms only. So the quality of the service, how much will be paid, eventually timing for the service. Whereas in an employment relationship, the control aspect of the relationship is much more clear, is clearer to say so. And it also, we can say the same for the risk test, for the tools test. So an independent contractor, they will have their own tools. If their tools are damaged or if they cause any losses, let's say the gardener is doing the garden, and there's a flying rock that goes to the neighbor's windows, and the window is broken. So it is the gardener that is liable for that. I am not liable. However, as an employee, if we cause any losses, it is the employer that is liable. Remember, we learned about vicarious liability already. And the employer cannot deduct any losses that the employee causes to them. That is also a difference in terms of the risk. And in terms of organization, so you can say that I am part of BCAT. You see my name listed in the website. When you registered, you also saw my name for this course. So I'm part of BCAT. I have a corporate or institution email and so on and so forth. Whereas an independent contractor will not be part of the organization. I can give you other examples. So let's say for most small companies, they don't need an accountant to be full-time hired for themselves. So they will mostly hire accounting services by either an accounting firm or an accountant, the professional, and either the professional or the accounting firm, they will provide services as independent contractors. They will not be employees. Why? Because the companies they are small. They don't need an accountant full time. So this is another example. Okay, and you can think of any other professions, several other professions that may be employees when companies are larger, bigger, But when companies are small, even medium ones, they are not employees. They're just hired on a service, on a needed basis. So they will deliver services. Okay? So is this difference between the relationship between independent contractor and employee clear to you? This is very important, not only for our course, but for our professional and business life moving on. Okay? And I know we employees, sometimes we apply for a job and then we get the position. However, when we get the contract to sign before starting the job, we are required to sign as an independent contractor. And I know that our bargaining power is very low, but keep in mind that this is illegal. And I know sometimes employees or people, they have to accept that opportunity because they need to work, they need to make money, but that is illegal. That is not legal. And if you accept that, keep in mind that if CRA finds out, they will fine the employer, but they will also fine the employee or the person providing the services because taxes were not withheld. If you ever get injured in the workplace because you are an independent contractor, you are not entitled to workers' compensation. So be cautious about accepting those types of relationship. Okay. So moving on, question for you. Sorry. A is the true one. Yeah, the critical factor is control. So the employer tells the employee not only what to do, but also how to do it. Exactly. It doesn't mean that we do not, as employees, we cannot exercise our experience or our discretion, but we need to deliver the outcomes, the objectives that we were hired to. So yes, we are under control. Okay. Any questions in any of the other alternatives? All right, so moving on. Obligations. So the employer is mainly under the duty to pay wages or salary and also to provide safe working conditions. By the way, let me tell you here right away, I may repeat this later on, but uh, we are we have the right to refuse unsafe working conditions, and on the top of that, we also have an obligation to refuse unsafe working conditions. But it doesn't mean we arrive at work, we see it's unsafe, and then we just say, hey, it's unsafe, I'm going home to watch Netflix. That's not the way to do it. So you need to report to your supervisor, to your manager, hey, the machinery is not working well, it's not safe, or this room I'm in, there's leaking, or there's gas leaking, or there are some electrical issues. So not only do we have a right to refuse unsafe work, but we also have a duty not to accept, because the main objective of health and safety legislation is to avoid injuries in the workplace in the first time. Okay, but sometimes injuries cannot be avoided and they happen. That's why workers' compensation exists. Obligations of the employee. So employee has to be competent, honest, loyal, punctual, has to act in the employer's best interest. And in some positions, mostly managerial positions, supervisionary positions, or even key positions, there will be fiduciary obligations. Okay, so and fiduciary obligations, remember, it is a trust relationship. Can someone say it is not safe to work due to COVID-19? Yes, you can, but you need to have objective grounds to that. So let's say the company has been complying with work and work um, health and safety BC requirements in terms of cleaning, providing cleaning resources, uh, protection equipment, etc. So if they have been doing everything, then I don't see you would have grounds. But in terms of COVID-19, I would say a good indication that it would not be safe, it is if the employer is failing to comply with the safety guidelines that have been put into place and are still being put in place in many fields. Okay, so it would need to be an objective objection. It cannot be subjective. Oh, I believe COVID-19 is in the air and etc. etc. No, this wouldn't work in my view. Okay, right. So in terms of the relationship, we've seen contract law, chapters 6, 7, 8, and 9. So the employment relationship is based on a contract. So everything we learned in contract law also applies for employment relationship. And by the way, I told you there that verbal agreements, they are as valid as written ones. And there are many employment contracts that are only verbal. It is not good for the employer at all, but still some employers are not aware. They would be better off having a written agreement. So they interview the person and say, can you start right away? Or can you start tomorrow? Can you come tomorrow? And then the person comes tomorrow. They have agreed on their wage, on some of the basic rights, etc. And yes, the verbal agreement is there. It is difficult to make proof, but verbal agreements are as legal as written ones. So they would be valid. We also looked at restrictive covenants before, and examples of them were the confidentiality section or non-disclosure, also non-competition and non-solicitation. So we've seen this related to contract law in general, and we are now looking at this related to employment law specifically. And here the limitations, they have to be even more reasonable. So courts, they will interpret those restrictions very, very strictly, because as a general rule, everyone has a right to make their living. Okay? But those restrictions, they are very common nowadays, and mainly for tech companies. So tech companies, they don't want their former employees, after the employees leave the company, to work for their competitors, or to disclose confidential information, or even to solicit on former clients, suppliers, or even employees, former co-workers. But remember, the restriction in terms of area and time, they have to be reasonable, very, very reasonable. Let's say 1 year, up to 2 years, I would say. But it will vary on a case-by-case basis because it depends on the position, it depends on the job duties of the employee. But they are very, very common nowadays. Keep one thing in mind. It is the obligation of the employer to have those restrictive covenants legally drafted. If they draft in a way that is illegal, in a way that it's not reasonable, You, the employee, you are not affected by that. So it is under the burden of the employer to legally and to properly draft those restrictive covenants in a way that they are reasonable, hence legal. So you should not worry too much. Or in other words, and this is not legal advice, it's just academic discussion. So if you read your employment agreement draft and you believe that those restrictions are not reasonable, one way is just to be silent, sign on them, and then after you leave the company, if you work for a competitor or if you invite other employees to come with you and the company threatens to sue you, it is going to be their duty on their burden to prove those restrictions are reasonable and legal. It is not on the employee. Okay, so you shouldn't worry much about them. When they are reasonable and legal, then you have to comply with them even after you leave your employment. Question for you, easy one. Exactly, that's D. We have to follow orders, but only the ones that are reasonable. Unreasonable orders, no, we don't need to follow. Okay, great, easy one. So termination. How does an employment relationship end? Well, it may end by two ways. It may end when the employee resigns, so the employee doesn't want to work anymore, or when the employer terminates the agreement, fires the employee. And employers can lay off their employees without any reason. So they don't need to state any reason. There's one restriction here. Employees cannot be fired because of human rights, because of any of the human rights protected grounds. So an employee cannot be terminated because they are foreigners, because they belong to this religion, because they are from this race, this color, this gender. This cannot be used as reasons to fire an employee. But let's say I don't want you anymore. I believe you don't perform well, or my company is not doing so well, business is not so good. So yes, I can just fire you. But I need to give you a reasonable notice. And the reasonable notice is minimum 2 weeks in general. As the more you work, the more weeks you will be entitled to. But initially, you will be entitled to, if you are working after 1 year, more than 1 year of service, you are entitled to 2 weeks reasonable notice. Or if the employee doesn't want you anymore, they say, no, just pack and go. They can pay in lieu of the notice. So instead of having you work during the notice for the 2 weeks, they just pay you everything you would be entitled to. Okay? And by paying you everything you would be entitled to includes commission, if you get commission pay, any bonuses, benefits, everything, as if you were working, but you are not. Why, as an employee, I would decide to pay in lieu of notice instead of giving you the reasonable notice? Well, eventually because I suspect you may be treating clients not in a good manner, or because I suspect the employee may steal some secrets or may not perform or work well. So I'd rather just pay in lieu of the notice and let you go right away. Okay? Who decides? Who decides if they will give you reasonable notice or a pay in lieu of the notice? the employer. The employer has the sole discretion to decide on this. Do you by law have to give 2 weeks if you quit? Yes. This may be surprising. I would tell you later on, but I'm just telling you now. Yes, the same obligation for the employee. The employee also has to give a reasonable notice to quit. But what happens is that if the employee doesn't give the reasonable notice, the employers in general, they don't sue the employee to pay this amount, this 2-week amount, because the legal costs usually are not worth. And mainly for low paying employees, it is not worth. But if the employee gets a high pay and they just quit without any notice, yes, the employer is entitled to sue the employee. What if you were working there for like 20 years? Is it still 2 weeks? No. Then it's going to be 1 week, 1 week for each year, limited to 8 weeks. So it's going to be 8-week reasonable notice minimum. In principle, yes, it's going to be more. So it's usually 1 week per year of service, but limited to 8 weeks. It doesn't need to be more than 8 weeks. Okay? Yes. Another way to fire someone is to fire with just cause. So with just cause, the employer does not need to give reasonable notice or pay in lieu of notice. And what is just cause? Well, just cause is when the employee breaches the employment agreement. So, for example, here, one of the obligations. If the employee is not competent, is not honest, is not loyal, is not punctual, those may be grounds for just cause dismissal. However, it is very hard to prove just cause dismissal. So employers would better off fire an employee, dismiss an employee, giving a reasonable notice or paying in lieu of notice. The exception would be if the just cause is too serious. Let's say there was a criminal event, there was a clear sexual harassment in the company, or there was a theft, and there are recordings for this. So those are serious issues in which a just cause could be more successful in court. But if the employee is not punctual, is not loyal, courts usually require a progressive disciplining process. So the first time you learn your employee is not behaving well, you would give a warning. This warning could be verbal, could be in writing. It's better if in writing, but still you could decide on any. And then the employee keeps on performing that way. So you would give a second warning, you would offer the employee a chance to improve, and then you would give a final warning. And then only after the final warning, only after you have informed the employee that their job is at jeopardy, then, and if they keep on breaching the agreement, then you would be more successful with a just cause dismissal. Okay, so it's hard to have just cause dismissal, a successful one, except, as I said, for very serious misconducts, usually in criminal nature. We discussed in our first slide the minimum wage, vacation, rest period, etc. So those are the minimum. Employers, they may offer more. So if in my employment agreement there's no wage there, I know I am entitled to minimum wage because that's the minimum one person can get. But employers, they may offer more. I told you, they may offer more vacation time, more vacation pay, higher hourly wage, etc. One thing is here, minimum wage, is it age restricted? No, no, not in here. That are I don't know which province it is, but there's one province in which students under 18 they get less. But no, not here in BC. There's no restriction for wage. So, well, if the reasonable notice I told you here, I informed you here, they have to be in writing in the employment agreement. And when I tell you they have to be in writing, your conclusion for a verbal agreement is that there's no written reasonable notice in a verbal agreement because it's a verbal agreement. And even some written agreements, they forget to have the reasonable notice clause or section. In those situations, courts, they will set the reasonable notice, but not following legislation. They will follow their own way. So this is known as the common law reasonable notice. So let's say an employee was working for 20 years, and then the employee was dismissed, and without any reasonable notice, and there was no written agreement for that employee. So this employee decides to sue the employer for wrongful dismissal, and the courts, they will look at the length of service, type of the job, age of the employee, eventually the employee, because the employee had been working for over 20 years, so the employee is of an old age already, qualifications, availability of other employment, and then courts, they will determine their own reasonable notice. I've seen cases in which employees were awarded up to 5 years, 3 years. There was this pastor here in Lower Mainland, one real case I saw. The pastor was awarded 1 year reasonable notice. And why so long? As I told you, courts, they use their own criteria, those criteria, length of service, type of job, etc., to set the reasonable notice. So if you ever become a business person, if you have your own company and you hire people, make sure first you have a written agreement, employment agreement. Second, you have a section in the employment agreement related to reasonable notice. If not, you may be in a high risk. Okay? Just cause, as I said, requires no notice, and those are some grounds for just cause. But remember, most of them require progressive disciplining. So the employee was disobedient or the employee has been absent. I cannot dismiss the employee right away. I need to give one warning, second warning, eventually third warning. Okay? The more serious the conduct is, then the higher the chances for the employer are for a successful just cause dismissal. Illness and disability. Well, if you don't mind, let's have a break in here. Let's be back 7:05. Is it okay? Resuming. So now we need to talk about illness and disability. Why? Well, first of all, you may remember in contract law, actually chapter 9, when we talked about the end of the contractual relationship, we discussed one of the ways to end a contract was by frustration. Remember frustration being an outside unforeseen event that makes performance impossible. So let's say for in an unfortunate event, an employee gets a terminal illness, so they cannot perform their obligations under the employment contract. And this is unforeseen. This is usually outside of their control. So In some circumstances, as this one, a terminal disease, um, illness may constitute frustration of the contract, so the contract is ended. In most cases, however, companies do offer, not all cases, but in most cases, companies offer insurance, long-term disability plans, etc. But one other thing we need to talk about illness and disability is related to the duty of the employer to accommodate um, the employee as based on their illness or disability, because that illness may be temporary or even permanent. The same thing for disability. So what I mean here is the employer. Let's have as an example BCAT. BCAT is a big institution. So let's say a driver cannot drive anymore because of an illness or a disability. So BCAT has to offer that employee a different position. They are required, based on employment legislation, they are required to accommodate the need of the employee. This accommodation, however, is limited to the extent that it does not cause the employer an undue hardship. And with an undue hardship, my example will be with a small company. So let's say this is a small company, this is a small coffee shop where the owner works and there's only one employee. And the employee becomes temporarily disabled or even permanently disabled. It's very unlikely that the employer in this example will be able to accommodate the employee. So, summarizing this, employers are required to accommodate any changes related to illness or disability. However, only to the extent that it does not cause them an undue hardship. Because if it does cause, then the contract is frustrated, is ended, is terminated. Okay? Um, Moving on. So layoff. Employees may be laid off temporarily. However, temporary layoff needs to meet two requirements. One is it has to be a clause, a section in the employment agreement, or it has to be an industry practice, such as for food industry, for some other seasonal industries. So if it is an industry practice or it is clearly prescribed, clearly present in an employment agreement, then it is possible. The second requirement is that it has a limit in BC. The limit is maximum 13 weeks. So in times now of COVID-19, yes, many employees have been laid off temporarily. However, as per current legislation, current Employment Standards Act, maximum 13 weeks. If an employee has been laid off temporarily and it's been already 14 weeks, then they are entitled to reasonable notice. If not, it means they have been wrongfully dismissed. And this is quite normal because employers rely on the fact that not all employees know their rights, their employment rights. So I've seen cases already. Even former students came talk to me saying that they were sent home because there was no business anymore, and they would get a call back to return to work, and it had been about 4 or 5 months, and they never got a call back. So this is clearly wrongful dismissal because the temporary layoff has a limit of 13 weeks. Constructive dismissal. What is this? This is a legal concept, which means whenever the duties of the employee are changed without the employee's consent, it may constitute constructive dismissal. Simple example, I was hired to be an instructor at BCIT, but then my associate dean tells me that from Monday on, I'm not delivering lectures anymore. I will be just drafting articles. And I was not hired to write articles, to research and write articles. I was just hired to deliver lectures, mark assignments, assessments, etc. So if I don't consent to this change, I am a victim of constructive dismissal. And then constructive dismissal, in other words, is a breach of contract where the employer is breaching the agreement, not the employee. So the employee could leave the employment relationship and could sue for wrongful dismissal based on constructive dismissal. Another way that constitutes constructive dismissal is when the working conditions become intolerable. So let's say you are a victim of harassment, you have reported already to your supervisor, bosses, managers, but nothing has been done, or whatever has been done was not sufficient, and you are suffering bullies, etc. So those situations also constitute constructive dismissal. Again, you may leave work and sue for wrongful dismissal. One thing is that when the employee is a victim of a breach of employment agreement, they may leave the employment relationship. However, they have to mitigate their losses. Remember, we saw this in contract law. All victims of a contractual relationship, they have the duty to mitigate their damage. So this also applies for the breach of an employment agreement. What I'm saying here is you leave the employment, but then you update your resume, you try to apply for other jobs. It doesn't mean you need to get another job, but you have to show the court, if needed be, that you attempted to mitigate your losses, your damages. Okay? Question, can you terminate an employee because this person has been away for more than 13 weeks and the reason is scared to work due to COVID-19? Yes. So, well, it means the temporary layoff is maximum to 13 weeks. So just before 13 weeks, the employer would call the employee and say, hey, come back to work. I have here the safety equipment, etc., etc. Everything has been was taken care. But then the employee said, no, sorry, I'm not returning. I'm scared of COVID-19, etc. So this constitutes an abandonment of the employment agreement. So in this case, the employee is abandoning. The employee is resigning. Okay. So and even if the employee is not so clear in resigning, again, this constitutes abandonment. So the employment agreement will be terminated by the employer. Okay. Right. Moving on. So wrongful dismissal. Well, let me tell you this just now. I could have told you in the very beginning, but I'll tell you this right now. There are basically only two situations in which an employee can sue the employer. One situation is constructive dismissal, as we just saw. Second situation is wrongful dismissal. But then you ask, well, but I have a lot of other rights. What if I'm not experiencing those rights? What if my employer has been abusing on those rights, etc., etc.? So in those cases, you don't sue. In those cases, you file a complaint with the Employment Standards Branch. Okay? So for employment relationships, we only use the courts basically for two situations. Actually, I'm saying two, but it's actually one. which is wrongful dismissal. Could be wrongful dismissal related to constructive dismissal, as I just explained, or wrongful dismissal because you were terminated for an illegal reason. Okay, so only in this situation you actually sue the employer. In all other situations, so let's say your employer is not paying you properly because of your overtime, your employer is not giving you the 30-minute lunch break, uh, your workplace is not safe enough, etc., etc. So all this, you will file complaints with the employment standard branch, with the employment branch. Okay, so keep that in mind. Well, when you sue for wrongful dismissal, actually you are suing for the amount you would have received if there were no breach of contract. Okay, so let's say you are entitled to 2 week reasonable notice, and you were not giving the 2 week reasonable notice, nor were you given payment in lieu of the notice. So you can sue to get that amount. Constructive dismissal, the same thing, because you left the employment agreement because you were a victim of a constructive dismissal situation. You are also entitled to minimum 2 week notice. Could be longer, as we already discussed, in case the length of your service to the company is longer than 1 year. Okay? And also, when you are suing for wrongful dismissal, so on the top of this amount you would have duly and legally received, you can also sue for defamation if you were a victim of defamation as well. You could also sue for intentional infliction of mental health. So remember those torts you saw in chapter 4? You could also add damages in case you were also victim for any of those torts. Wrongful living. So we discussed this already based on a question. Yes, employees must give employer reasonable notice before departing. That's what I told you before. What happens though is that for low paying positions, employers do not sue employees because of the legal costs. It is not worth. Okay? But yes, legally speaking, you have to give a reasonable notice before you resign. How liable are employers? Well, we learned this already. Employers are vicarious liable for all wrongdoings committed by their employees in the course of employment. If it is outside the course of employment, then only the person, the employee, will be liable. But if in the course of employment, while performing the job duties, the employer is vicarious liable. Remember, vicarious liability is a form of strict liability in which, in this case, the employer is liable even though the employer was not at fault. It was the employee that was at fault. However, vicarious liability exists to protect the victim. So the victim has better chances to get their award paid if they win the lawsuit by the employer rather than by the employee. Okay, so that is just a review. And in most cases, businesses, employers, they will carry liability insurance. So in case they have to pay compensation because of vicarious liability, they will claim on their insurance. Also, well, misuse of computers. By the way, the laptop computer I use belongs to BCIT. Because it belongs to BCIT and I use it and I have to use it for my job duties, BCIT is vicariously liable in case I download illegal content or illegally download content without paying the proper fees, etc. So in this case, the employer can monitor my activities. There's one main requirement. I need to be forewarned that my activities on the laptop computer will be monitored. And usually companies do this in their policies. So when we sign the employment agreement, one of the clauses or several clauses, they say that we also agree and abide to the policies effective from time to time. And there's usually an online internet or online or computer use policy. And so because we agree to those policies, and there usually in the policy they say that they will monitor our activities using their resources. So that's also something important. Yeah, I was talking about privacy law. So we have a privacy right, but as I said, monitoring is allowed as long as I am told beforehand. In terms of legislation with regards to employment, I told you in the beginning when we discussed about holidays. I told you that federally regulated employees, they follow federal holidays, and provincially regulated employees follow provincial holidays. Well, this distinction is related to almost 90% of employees in Canada, they are provincially regulated. What are provincially regulated employees? Who are the provincially regulated employees? Good answer to you is the provincially regulated employees are the ones who are not federally regulated employees. I'm joking. But I'm answering this way because it's easier to know who the federally regulated employees are. So the federally regulated employees are the ones who are employed by companies which services, which businesses are of national interest. So good examples will be transportation, banking, airlines, interprovincial businesses. So those are all examples of companies which employees will be federally regulated. And those are the fewest number in Canada. The highest number in Canada will be for provincially regulated employees. And provincially regulated employees, there will be a provincial act. And this act in BC is called the Employment Standard Act. Each province will have their Employment Standard Act. So it is from this act, from the Employment Standard Act, that we get our the wage, the minimum wage, our rights in terms of work hour, overtime, everything we discussed in the first slide, and many, many more things. And by the way, do you know which is the highest minimum wage in Canada nowadays? I'll tell you, it is $15 in Alberta. So Alberta has the highest minimum wage in Canada as of today. And the lowest one is in Saskatchewan. It is $11.32. Why am I telling you this? Well, just to confirm what I'm telling you with regards to the Employment Standard Acts, the provincial acts. Well, if they are provincial acts, it is correct to conclude that the acts are not the same. They are similar to one another, but they are not the same. So if you have a job here in BC, you have to rely on the Employment Standard Act of BC. But if you move to Ontario, if you move to Alberta, you have to rely on those Employment Standards Acts. And that's why the minimum wages are different from province to province. So what I'm saying is an employee working for Tim Hortons in the same position of another employee in Alberta, if they get minimum wage, they get different wage because the minimum wage is different from one province to the other. Okay, so not in this course, but if you take employment law as a part-time course, as I told you in the beginning, we would study the Employment Standard Act in more details. Okay, so whenever you have a doubt about your rights, you would refer to the Employment Standard Act. And again, most, if not all, issues that may take place in your employment relationship related to the Employment Standard Act, you will not sue the employer. You will file a complaint with the employment standard branch. Okay, you will only sue in cases of wrongful dismissal, constructive dismissal. So the employment standards, they will set the minimum protections, they cannot be waived by either employees or employers, but mostly employees. So employees cannot waive their rights. And employers, they can offer more than the minimum. And I had told you this already. This termination under cause, we discussed already. No notice is required. So human rights legislation. Why do we touch upon again human rights legislation? Well, in BC, over 60% of the human rights complaints, and remember, human rights issues, we don't sue, we file complaints in the Human Rights Tribunal as well. This you saw in Chapter 3. So over 60% of the human rights complaints in BC, they are related to employment situations. So human rights is very important in the workplace. Okay, and you already know that you have the protected grounds such as gender, age, disability, ethnic origin, religion, etc. So if you're ever discriminated in the workplace or even outside the workplace, you can file a complaint against the offender. The employers, they may discriminate as long as they have a bona fide, they have a genuine, they have a true occupational requirement. So let me give you this example. People with disability, they cannot be discriminated. But let's say this is a small company, they need to hire a new employee, and because they are small and because of the job duties, they cannot have a disabled person. So in this specific situation, they could discriminate, and they could decide not to accept disabled people applications. But whenever a discrimination takes place based on a bona fide occupational requirement, it is the burden of the employer to defend themselves in case anyone files a complaint. Okay, so if you ever become a business person, or if you are a business person, if you have your own company and you need to discriminate on a bona fide occupational requirement, make sure you have all the records, you have all the explanation, and they are solid explanations in case you get a complaint based on your discrimination. Because again, if you can accommodate, you have to accommodate. Okay, the same thing as with illness and disability we saw some slides ago. You have to accommodate unless such accommodation causes an undue hardship to you. Okay, so that's very, very important. Those are some of the issues that can also be grounds for human rights discrimination and issues. So health and safety. Health and safety. The objective here is to prevent injuries in the workplace. That's why there are a lot of fines. Directors or senior executives, they may even face prison times if they fail to comply with health and safety rules. There was this hospital in Coquitlam, if I'm not mistaken. Early this year, they got a fine of over $600,000 because, if I'm not mistaken, nurses were victims of harassment, and the hospital management, they never corrected such situation. So they were fined because of this. So health and safety is very, very serious. And the objective is to prevent injuries in the workplace. But there are cases that even though all preventive measures were in place, but accidents unfortunately happen. So if accidents happen, if employees are injured or get sick because of work in the workplace, then they may be entitled to workers' compensation. What is workers' compensation? Well, it is provincial, by the way, so each province will have their type of workers' compensation scheme, and it functions similarly to an insurance. It's like an insurance, but it is mandatory for some industries here in BC. For other industries that workers' compensation is not mandatory, they may decide to opt in because workers' compensation is a very interesting insurance scheme for both employees and employers. What happens is if the employee is injured in the workplace, even if they were negligent, even if they were careless, they are entitled to workers' compensation. The workers' compensation is funded by premiums, and those premiums, they are paid only by the employer. The employee, you may check your pay stub, you will never see workers' compensation deduction there. And if you ever see it, this is illegal. You should file a complaint. It is illegal to deduct workers' compensation premium from the employees. And by being entitled to workers' compensation, the employee is actually waiving their right to sue the employer. Okay, because let's say I was working and I suffered an accident while working. It would be probably a negligent tort for committed by my employer. So I would sue my employer based on negligent tort. But because there's workers' compensation, I am waiving my right to sue because I will be compensated by the workers' compensation. So that's how the scheme works. Employment insurance is federal. So because it is federal, sometimes the rules change in the federal level for employment insurance, and the rules in the provincial level have not changed yet. This happened when the leave for maternity leave, the length of leave was increased, and the provincial leave was not increased yet. But now they are going together. So keep in mind that it is federal jurisdiction. And when do we use our EI? We use our EI when we are in a leave. So maternity leave could be all the leaves that are legal, that are prescribed in the law. And also if we are dismissed, if we are dismissed without just cause, without any cause. So we are entitled to. Who funds the employment insurance? Both the employer and the employee. So you may see the deduction for employment insurance in your pay stub. Okay, excuse me. In case you voluntarily leave your employment, you resign, you are not entitled to employment insurance. So one last question for you, and I just want to share some words on unionized places with you, and it's going to be it. Yes, that's B. B, constructive dismissal. So constructive dismissal is demoting an employee or unilaterally changing the job duties or the nature of the job. So as I mentioned before, this part you may disregard for your final exam. At BCAT, if you take the courses labor relations, you may see unionized workplaces in depth. I just want to share some words here with you. So when a union is created, um, the workplace, the union is created and it has to be certified and etc. And by the way, I'm just sharing this with you for news purpose. It's not going to be in exam or anything, as I said. So when a union is created and certified, etc., it becomes the entity that will negotiate with the employer. So after a union is duly certified and is in place, the individual employee will not negotiate their employment agreement with the employer anymore. It is going to be the union who will do this. And the name of the agreement that will be negotiated is not employment agreement anymore. It is called collective agreement. Let me give you some examples. I am a unionized employee because all faculty members at BCAT, they have to belong to the union. So we have just reached a tentative agreement with BCAT because our collective agreement expired last year. By the way, most faculty members, teachers in BC, if not in all Canada, but in BC for sure, they are renegotiating a new agreement as of now. So, by the way, you can go to BCAT, you can log on to bcat.ca, human resources, um, collective agreement, if I'm not mistaken. You can read our collective agreement if you are curious about it. Those collective agreements, they are long, they are over 100 pages, and they have the same rules for all employees that belong to that union. So all instructors, they have the same rights. There are some changes in terms of seniority, in terms of experience, etc. But as long as you are a faculty member at BCAT, you will be most likely entitled to the same rights. So that's how unionized workplaces work. Only unionized employees are entitled to go on strike. That's why last year here in Canada we had the post office strike. We also had a threat. No, I think it was a threat for TransLink employees to go on strike. But unionized employees can only go on strike after the agreement expires. And why? Because after it expires, the employees, they can use the strike as a leverage to force the employer to negotiate or to reach an agreement with them. There are rules for strike, etc., but just to give you an idea. And one last thing I would like to mention to you. For example, I know that IKEA Coquitlam, there's no union there. But for IKEA Richmond, there's a union. So you see, they are two different, it's the same company, but it may be two different corporations. And for one location, the employees were able to organize themselves and create and have one union certified. So if you work for IKEA, Richmond, you have to join the union and you have to pay union dues, etc. Whereas if you work for IKEA Coquitlam, you are not a unionized employee. So just to give you a practical example and real life issue. All right, so that's what I wanted to share with you with regards to employment law.